Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 22-481 Campbellton Road versus the City of San Antonio from Bosque County and the Fourth Court of Appeals District. Justice Lehrmann is not participating in the decision of that case. 22-585 Texas Department of Transportation against Self from Montague County and the Second Court of Appeals District. And then finally 22-843 Texas Tech University System versus Martinez from Lubbock County and the Seventh Court of Appeals District. The court has allotted 20 minutes for each side in each of the cases, and we'll take a brief recess between the cases, completing them this morning. Justice Devine cannot be present this morning, but expects to participate in the decisions of all three cases. The arguments are being webcast live and will be available in the court archives later today. We're ready for argument in 22-481.
May it please the court. Mr. Jefferson will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. This morning, I'd like to cover three topics in my argument. The first is that the contract that's at issue in this case is most definitely a contract for goods or services under the precedent of this court. Secondly, Campbellton was not too late in asking SAWS for delivery of the EDUs that SAWS contractually promised to deliver. And then, subject to questions from the court, I would like to discuss distinctions between the Kirby Lake case and the Lubbock County case. So first topic, again, subject to any questions, is this was definitely a contract for goods or services as defined in Chapter 271.
Was it unilateral or bilateral?
Well, there are aspects of it that are both. I don't think that that's an issue for today, but let's assume that it was a unilateral contract. Even if we assume it was a unilateral contract, we performed. Campbellton performed. And because Campbellton performed, it's an enforceable contract by this court's precedent.
If it was bilateral, was there anything in the contract that was signed that would have been enforceable against you at the time of signing? For example, would it have been something that if you had not deeded over the improvements that SAWS could have brought a breach of contract claim against you for that or not?
Well, Justice, that is a merits question, which I understand.
Well, it might be a merits question in some ways, but if we're trying to figure out when the contract was entered into, when there was something that actually was an enforceable contract, if it's bilateral, I think we might need to answer that.
I will answer
unless you're telling me that the parties have essentially stipulated that it's unilateral.
I don't believe the parties have stipulated that it's unilateral. I think the language in the contract says that Campbellton will do certain things. It obligates itself to do certain things. That is a contractual promise that's supported by the promise to deliver what SAWS promised to deliver. In my opinion,
What was enforceable at that time?
Was it enforceable at the time the contract was? Well, so we could have walked away from the contract when we signed the contract. And at that point, had we done that when the contract was signed, I doubt that SAWS would have had a remedy.
What if you actually did the improvements but didn't convey them? Would that have been something that could have been subject to a breach of contract claim by SAWS against you?
I think the mere passage of time could have been subject to a contract claim by SAWS against us. If we promised to do something and didn't do it, the contract doesn't say by when it had to be done. It said by when it had to be completed. But there is the law implies a reasonable time to perform. We made a promise to perform. If we had not performed, SAWS could have said, you've delayed our ability to develop this property and to sell our EDUs to others. And we could have entered into contracts with others. And we relied upon your promise to perform under this contract. And in doing so, we've been damaged. So yes, I think in that sense, it could most definitely be construed as a bilateral contract. But it's definitely a contract for goods or services. The goods included a lift station, a physical lift station that was in SAW's core business and included the oversizing of sewer lines. I mean, the construction and oversizing of sewer lines. Those are things that we contracted with SAWS to do, to provide for them. SAWS is a governmental entity. One of its responsibilities is providing sewer service. That, I think, is undisputed. And so we did provide goods and services, not only by providing the infrastructure itself, but by providing the services needed to develop the infrastructure, the engineering, the development plans, et cetera. So this was most definitely a contract for goods or services.
Is the existence of the neighborhood a service to SAWS?
Well,
Do they care one way or another, like whether this is there?
SAWS doesn't develop property. SAWS doesn't make from my perspective, SAWS does not make a determination about where property is going to develop or when it's going to be developed. But when it's developed, SAWS has the obligation to deliver sewer service.
But it wouldn't have been developed unless you got approved and had this agreement. So it's like the approval of the existence of the whole thing is wrapped up with the, service that you're saying was provided. And that's why it's a little different than the typical goods and services case.
Well, there's no question that they're mutually beneficial. Both parties benefited from this contract. But SAWS has an obligation to provide sewer service where there is development. When this development first happened, this was raw land, okay? But it was being developed. Clearly, it was being developed and being developed rapidly in that part of town. My client was one of the landowners that owned this raw land. And so in order to get, so SAWS does have an interest in, if there's raw land being developed, ensuring that there is sewer service and that there is appropriate sewer service. And in making sure that the infrastructure in place is sufficient to satisfy the development that they anticipate, that all the parties anticipate. SAWS keeps track of that, and that's in the contract. They keep track of capacity, of sewer capacity. So the existence of a neighborhood is not something that SAWS would do. I mean, SAWS doesn't sell homes, it doesn't acquire land, but once it's there, SAWS has an obligation to provide the service. And SAWS charges for that obligation. It charges for sewer service, it charges for water service.
I guess the question is, would the neighborhood have ever been there if they didn't agree to this?
No, it would not.
So it's not like there was going to be a neighborhood without a sewer system.
Correct.
So,
There's never, and which is why one doesn't go without, one goes with the other. I mean, these are joint things. You can't develop. There's a saying that, if you can't flush it, you can't sell it. Wherever there are people, there are toilets, and wherever there are toilets, there is a sewer system is necessary. And so that's what was, and SAWS provides that service. But you're correct that SAWS doesn't develop neighborhoods, but it does provide the service once it's there. And that's part of it's not only its mandate, but it also generates revenue from that activity. So in addition to the infrastructure on the ground, and the service needed to provide that infrastructure, and that is engineering services. The contract says that that Campbellton would provide a project master plan, an engineering report, a water plan. All of those things, Campbellton agreed to provide to SAWS by the express terms of the contract. Those are all matters within SAWS' responsibility as the governmental entity that it is. And so there's no question that this was a contract for goods or services to SAWS.
So if there had not been this kind of arrangement and just the development was going to happen, and forgive my ignorance, but how would it have actually worked out so that you could have something to flush and thereby to sell? If Campbellton said, well, we're not doing all of that, we're gonna build the neighborhood.
Well, so, I mean, just like when you build a house, I mean, what generally happens, well, first of all, we couldn't get permitted for sewer service, and we would have to provide sewer service somehow. I'm gonna back up for just one moment. Our client is a land developer. They're not a house builder. So our client doesn't actually build the houses. All it does is it invests in property with the hope that it can sell the property to developers who will put houses on the property. And once the developers are, what we want to do is, what the landowner wants to do is sell the land with the entitlement to sewer already there. So it can go to the market and it can say, we've got this land, and by the way, we've got sewer secured. And because we have sewer secured, you don't have to worry about that. And we can make more money on the sale of the property.
When you say that SAWS has the obligation to provide this service, that comes only after the permit has
Yes.
been, and the permit would not have to necessarily be granted if you don't agree to do all the things that we're talking about here, or not?
Well, all of the things that we're talking about. So SAWS has the obligation to provide the service. SAWS does not have the obligation to pay for it. Developers pay for it. I mean, generally speaking, that's how it happens. But it's in SAWS' interest that developers pay for the service, for the infrastructure.
If the developer decided, well, we're just not gonna do that, we'll pay whatever SAWS wants, but SAWS would then itself do it, would it have the obligation to do that? Could the permit be denied on the ground that you're not doing it yourself, you're not willing to enter into a contract like this one with SAWS? That's the question I have.
What SAWS would say is, when we went to them with our master plan, there was not so this was raw land at the time. Eventually it would be platted. So the developer, the person that we sold the land to, would say, we want to put these many houses on the land, and this is how much sewer service we're going to need for these houses. SAWS would then say, just like it said to us, or like it said to our successor, SAWS would then say, we don't have the capacity in our system to service that amount of sewage. So you must build the infrastructure necessary, or we're not going to provide you with sewer service. And then we would be put to the choice. We would build the infrastructure that they said, or we would find some other way. I'm not sure there is one. I don't know if we can put septic tanks on a subdivision like this. I doubt it, but.
If a city is permitting a restaurant and says, okay, you're gonna change this from a vacant lot to a restaurant, and so if we're gonna issue you this permit, you're gonna have to build like a driveway and a sidewalk, and the driveway and the sidewalk are, in the city's right of way. Is that a contract for services to the city because they end up owning the sidewalk, or is that just the city's administration of a permitting regime?
So there's a case below that I don't recall the name, that it's on those facts, where the developer was told, you must build a street, and if you build the street, then you can build the restaurant, or whatever the commercial entity was. And my recollection is the result was that's enough of a benefit to the city that it qualifies as a service to the municipality under 271.
But beyond the permit, there was the EDU credits.
Yes.
And so was that a different obligation than the ordinary administration that a permit would involve? In other words, they can attach conditions to a permit, but if they're asking you to do something beyond the scope of what is necessary to obtain a permit and offer in exchange these credits, is that a separate bargain?
Yeah, I mean, this was a totally voluntary exchange. I mean, the party, when this contract was signed, everybody was happy. And Campbellton was happy to accept EDU capacity. And there weren't permits issued at the time because there weren't plats, and the contract speaks to that. The plats would come later, and the plats would be what determined how much sewage was necessary. We got 1,500 EDUs reserved by the contract, but the plat eventually would tell what capacity was necessary for the development. But it's not unusual. I'm not sure I'm answering your question, Justice, but it's not unusual for the developer to say, yes, we'll accept either EDUs themselves, or we'll accept connection fees when they're made, in order to pay for the infrastructure that we put in the ground. Not sure if that got you to answer your question, but so there was the second issue that I wanted to discuss was, and I've got 2 minutes. So Campbellton was not too late in asking for this for the delivery of the promised EDUs. The contract says that Campbellton would receive vested rights to EDU capacity if it built the infrastructure. By building the infrastructure, Campbellton paid collection impact fees. By paying collection impact fees, Campbellton earned a vested right to capacity under the contract Roman numeral 3D at page 8 of the record. SAWS contracted and said that it could not reduce that capacity. And based on those representations, Campbellton constructed the infrastructure that SAWS uses today. Campbellton constructed the infrastructure. SAWS then, and what Campbellton should have done is said, okay, we've got this contract that reserves 1,500 EDUs. That capacity is spent. We can't use that elsewhere. We've promised Campbellton that we'll use it for them. Instead, they entered into deals with other developers, gave that capacity to others, and then when we went and said, it's now time for you to deliver on your promise and collect on these EDUs, SAWS said, oh, sorry, there is no unused EDUs. There's no unused capacity.
Does SAWS generate income from the existence of the additional sewer infrastructure?
Yes. The more capacity that there is in the sewer infrastructure, the more revenue SAWS can generate for itself. SAWS in two ways. One, SAWS obtains collection fees, and secondly, SAWS pays for treatment. So SAWS receives payment for treatment, month-to-month treatment that we all pay with our utility bills.
By increasing that capacity, by your increasing the capacity and then SAWS using it for others, is it essentially SAWS not holding other people to the same kind of deal that they were making with you? Like other people got a much better deal because they did not have to, or was this people that didn't have any obligation to develop capacity existing? How did that work exactly?
Could be both. I mean, but in this case, the contract says that SAWS would maintain accurate records of capacity. Our position is accurate records of capacity means you can't use those 1,500 EDUs for anybody else. That's used. Those EDUs are spent. And what SAWS did was spend them again, spent them with another developer. And then when we went back to them and said, it's time for us to have them, they said, no, you got to build more infrastructure.
How long would they have been required to reserve them for you, in perpetuity?
Yes, they were vested rights. They were our rights, our property rights by the express terms of the contract.
Are they not subject to divestment if you breach the contract?
Potentially. I mean, I haven't thought about the ways that could happen. I suppose it could, but no. I don't think.
What if you
all
built
that
the
depended on
infrastructure and it didn't work?
Well, there's a provision in the contract that says if SAWS was unhappy with our work, SAWS had to give us notice and an opportunity to cure. And that did not happen here. The infrastructure is in the ground. SAWS is using it for other purposes to this day.
Any other questions? Thank you, counsel. We'll hear from the respondents.
May it please the court. Mr. Melkonian will present argument for the respondents.
Mr. Chief Justice, and may it please the court. An entity like the San Antonio water system only waives sovereign immunity if it enters into a contract that provides it with goods or services. If it's the one providing goods or services to another entity, that's not a waiver of sovereign immunity. And if through some kind of daisy chain of events, some kind of arguable service could be eventually provided to it, that too is not a waiver of sovereign immunity. Those are the lessons of Chapter 271 and of the cases of this court. The contract in this case is not such a contract. It is a unilateral option agreement that Campbellton Road had the opportunity to accept by performance within 10 years. We held capacity of EDUs for them for 10 years. They did not perform in that time, and therefore there is no sovereign immunity because there was never a contract that promised them goods or services. So let me address something my friend on the other side said first, which is that we performed. They have said repeatedly in their briefs that they performed under the sewer services agreement and therefore had vested their rights to the EDUs. That is incorrect, and it clashes with the record in this case.
So do we have to decide who wins on the breach of contract in order to decide whether there's immunity? Is that what you're saying?
No, Your Honor. I think.
Well, you just said they performed or not. That sounds like a merits question.
No, Your Honor. I don't think it's a merits question. There's, of course, an element of merits in that, but you don't need to reach that because this is a plea to the jurisdiction, and they had an obligation to set forth at least a scintilla of evidence that they performed. And
They
they've
gave you a plant.
No, Your Honor. First of all, there's no evidence of that. Let me address that in a second. But they have conceded they did not perform under this contract. Article 3D, which is the central obligation, says that they must pay the wastewater treatment impact fees in order to vest those rights.
So you don't have a plant that they built. Is that your position?
That's not my position, Your Honor. My
Okay,
position
so why is
is
that not a good?
it's not a good because it's not a right we had to the good. They had the opportunity to build and complete the contract in order to get the vested rights to the EDUs. And they have conceded, this is on page 9.
Who has control of the plant?
Your Honor, it's not in the record, so I don't want to make representations, but my understanding is we do. But that is not the point. This is their plant that they built, that they had an option to build in order to develop their property.
So if they want to go and take it back, they can?
No, Your Honor, they can't. But the problem is that they had a set of things they were required to do under the sewer services contract in order to vest the EDUs. That's what gives, even if they're right that a plant is a good or service, that's
But your
what gives
client
us.
didn't say, you failed to perform timely. As a result, we reject the lift station that you've provided, the infrastructure that you provided, because you did not comply with the contract. So we reject your performance, and we're not going to take possession of this.
No, Your Honor, that's not how this contract works. It's a unilateral agreement. They have to perform all the obligations in order to get the EDUs. Now,
Why haven't you waived obligations by accepting performance as it was done?
Well, they have not performed. They have not performed all the obligations of the contract. They say they haven't.
Again, that sounds like a great merits argument.
Your Honor, it's not a merits argument because I urged your honors to look at the record. The record here, if you look at the 4 pages of the clerk's record that they've cited for evidence that they actually spent even $1 on this supposed plant, there are 4 pages of the record. Each page is 87, 95, 190, and 256. The last one of those is literally their petition. That is not a scintilla of evidence as needed under the rules for a plea to the jurisdiction.
I'm sorry, you're saying they didn't pay to build the plant?
I'm saying that
It just appeared?
in terms of the record that is before the trial court and the record that is before this court, there is not a scintilla of evidence in this record that they did anything. But that's not my main point. My main point is that they concede they did not satisfy the contract under Article 3.d. They concede that they never paid the wastewater treatment impact fees, and it's all a package. They have to complete all of those, and then they get the EDUs that we're saving for them for a decade. They have all that time to perform. Once they perform, we would be delighted to hand them the EDUs, and they can build their development. But they're the ones who chose not to do that. And it can't be the obligation of the San Antonio water system to hold EDUs in perpetuity while other kinds of developers might need those EDUs. We want to make sure that the EDUs are given to the people with the best and highest use of the EDUs. And
But by the same token, if you are building a convention center and you say to the contractor, I'll reserve next June for your use in exchange for you building it, and then the next month you enter into a contract with an asphalt parking lot company and you say, I'll reserve next June for you, for your use in exchange for you building the parking lot. And you can do that seriatim, and the next June comes and everybody says, well, I want my use of the convention center, and it's been let out multiple times. And is that appropriate?
Your Honor, that's not appropriate, but it's also not what we did here. We held the EDUs for them for an entire decade, waiting for them to perform the obligations under the contract, and they never did that. They never did that, and they say they never did that. So in your scenario, I agree that that is an inappropriate way. If we had been sort of handing out EDUs, double dipping to everybody while we were supposed to be freezing the EDUs, I agree that that's inappropriate, but that is not what we were doing at all here. We held the EDUs, and we would have been delighted to give them the EDUs had they performed as required under the sewer services contract.
Why doesn't the Williams case eliminate the basis for saying that if it's a unilateral contract and all of these things happen, nonetheless, sovereign immunity has been waived?
Williams is the firefighters, Your Honor?
Yes.
Yes. Well, I think what the court said in that case is that the firefighters had fully performed. There's a paragraph about their full performance in that case.
Your view is that in order to know if sovereign immunity is waived, performance in a unilateral contract must be established
Must be at
conclusively?
least pleaded, not pleaded, but proven with a scintilla of evidence at the plea to the jurisdiction stage.
So
you
if we
can't-
disagree with you on the scintilla, I know that you very passionately think that we couldn't possibly reach that agreement, but if we do, then immunity is, that question is passed. And
If
we
you disagree
reverse.
with me about what the record shows, Your Honor?
Or, yes, just that if we conclude that there is more than a scintilla of evidence of performance.
So that part of my argument would be much harder because, one of our points is that they haven't performed under this contract. We will say we are not conceding that even if they had fully performed this contract, that there would be a waiver of sovereign immunity. We think there is a fundamental difference between how Kirby Lake works and how the contract in this case works. Kirby Lake is a one-year term. You pay money in return for sewer infrastructure. And candidly, San Antonio Water System does do those kinds of contracts. Those are called construction contracts, and we enter into them all the time.
Was there a monetary cash value associated with the EDU in the contract? Weren't they valued at a certain?
No, Your Honor.
Price?
I know the part of the contract you're talking about, that's in 3D as well. Those are the costs they have to pay us. It's how you calculate the amount of impact fees you have to pay us. So they have to pay us $1,000 per EDU of impact fees. But that's not a monetary value of the contract. That's what they have to pay in order to trigger the contract, which they never paid. So I don't think that's how you would think of the value of an EDU. I think the value of an EDU to them is some aspect of the profit they would have made by selling this property. And there must be a value they could derive of EDUs, but it's not in the contract.
So let's take this back to black letter contract law. If you have a unilateral contract that's accepted by performance, and someone partially performs, one side partially performs, and the other side accepts that partial performance, then what result? Is there a binding contract at
There's
that
a
point?
binding option agreement at that point. So that's what Restatement Second of Contracts 45 says, in our understanding. So then we could not take away their option. So if they want to perform, they want to complete performance, we can't say, no, we've now sold off the EDUs to somebody else. So we
But do
agree
you
with
get
that.
to keep the partial performance if they don't exercise the option?
Yes, Your Honor. And let me sort of dive into why that's fair, because I know that's a problem I've had with this case. Like, why can you spend some money and then you decide not to develop and then you've lost whatever amount of money it is? But that's actually economically efficient. That's what we want these kind of developers to do. If they thought it was economically efficient to go and develop the property, they would have finished it. And then they would have the EDUs that we promised them. But for them, the flexibility and the optionality they got out of this contract is what they were contracting for. They were cutting their losses. They decided to spend some amount of money developing, and then they realized that for whatever economic reason, whatever good economic reason they had, we trust them as sophisticated actors in the economic market. They decided not to develop, and that's perfectly fine. And so they ended up spending whatever amount of money they spent. Again, it's not in the record. But then they decided to move on, and that is perfectly appropriate.
The last
That is-
step of development is just the payment of the fees. Is that right?
Well, they didn't record a plat. They never developed anything on this property. The only time development has come up is years after the contract was long dead.
To have the vested capacity, your friend said it would have been vested in perpetuity if everything had, and they think it has happened. But do you agree with that? They would have had this forever, this right? If they'd finished.
I think that's right. I think we
Could
would.
they have then alienated that, sold that to someone else?
My
or was it-
understanding is no. I don't think it's a fungible product. I think perhaps.
How could it not be fungible? You've used it for other people.
Right, but they can't take EDUs that are attached to them and then sell them. I don't think there's a market mechanism.
Capacity is something that's just for that piece of property? From them,
I'm
but not for
hesitating a
you?
little because I think there's a provision that says a developer can use EDUs for their other developments. So it's maybe cross-transferable between themselves. But there's no open market to take the EDU and, go trade them, as far as I understand. It's certainly not in this record. But
But do they attach to the plat so that a successor can rely
yes,
on that capacity?
that's my understanding, that as soon as they're vested and they have the rights to the EDUs, they attach to that plat and the successor
So in
gets
that
them.
sense, they are transferable,
Transferable through
as a right attached to the, whatever the
to
property
real
interest
estate.
is.
Right,
yes.
but they're not saleable, you can't, there's not a stock market of EDUs that they can go and liquidate these EDUs, as far as I understand. Let me turn a little bit to the differences between Kirby Lake and this contract again. And I think I might have said this, but Kirby Lake is a one-year term. So if there's gonna be a waiver of sovereign immunity in that case, everyone is gonna know about it right away. The governmental entity offered to pay money for sewer infrastructure. They had a one-year obligation to build that sewer infrastructure. If they didn't do it, we could sue them, or not we, but the municipal authority in that case, and the developer could sue the municipal authority in return. That's what I think this court was saying. It would be unfair to have a bilateral contract where only one side could sue. But in this case, we have no right to sue them for anything.
So if Campbellton had completed the construction of the on-site, off-site systems, and if SAWS accepted them, could SAWS compel the conveyance of title to them under Section 2C of your contract?
We can't do anything, Your Honor, as I understand it, to them to make them complete this development, because that's the option they're buying.
Under my hypothetical, they completed the construction of those systems and SAWS accepted them.
I still think
My understanding was that at that point, the promise was, if we do this, you can't force us to do it, but if we do it, we must convey title to SAWS. Is that not an enforceable promise?
No, I don't think it's an enforceable promise until they develop the property. So until they turn on the system and they hook up to our system, there's no promise there. They can walk away as they did. They did not complete this contract within the 10 years.
Even after SAWS accepts something,
I don't read this contract as requiring anything like that. Where I would point, Your Honor, is to Article 12, the termination provision. The termination provision says that this contract terminates at a term of 10 years. And the thing that prevents it from terminating is completing all the obligations of the contract, one of which is the wastewater treatment impact fee. They concede, as I've said, that they never pay the wastewater treatment impact fee. And if this were a true bilateral contract where we could compel them, I would expect to see some kind of remedies provision there. If you don't complete this contract, you have to pay us liquidated damages, or we can be sued, or maybe there's a dispute resolution provision. There's not, because we can't sue them. They can walk away anytime they want.
To the extent that the statutory text in Chapter 271 is amenable to different views, do you think that we should prefer a view under which both parties can know when the contract is executed whether the contractor is going to have a claim against the government, as opposed to what you seem to be arguing, which is that you won't know for many years, depending on how they behave, whether or not they can sue?
Well, actually, I think, Your Honor, I want to be arguing that we do want to know as fast as possible. And the argument that my friends on the other side are making is that they could appear in this court 50 years from now and make the very same claims they're making about waiver of sovereign immunity that they're making today. There's no end limit to their argument, because they think that this 10-year period immediately waived sovereign immunity. So I would say you need to put your thumb on the scale when you're interpreting the text of 271 in favor of sovereign immunity, as this court has said, to prevent that sort of tying the government to the mast problem that this court has talked about, where a government in 2003 could control someone in 2080 and cause EDUs to be held in stasis for decades that could be used to develop San Antonio in the correct places. But
the question is, shouldn't we prefer a rule under which you're looking at the nature of the contract at the time it was executed to know whether immunity is waived, so that everybody at the outset can know whether immunity is waived by this thing that I'm signing? or it seems you're arguing for a more open-ended analysis where you've got to sort of look to, other things that happened later to know whether back then we waived immunity.
Well, I think, Your Honor, as to that question, if you look at this contract, you will see that sovereign immunity is not waived under our rule. Under our rule, if it's a unilateral contract where there are no enforceable obligations on both sides, at that time, sovereign immunity is not waived. If you, as the developer, perform.
But isn't your impact fee argument, you're arguing that that's an enforceable obligation that they failed to comply with, and as a result, they're not entitled to the credits?
It's
How-
not sorry.
That seems inconsistent with saying there's no enforceable obligation.
I don't think it's an enforceable obligation, Your Honor. We can't sue them to make them pay the wastewater treatment impact fee. They hold the keys in their pocket. If they want to develop and they want to do it within 10 years, they pay the wastewater treatment impact fee.
No, but you can argue, we're not liable under the contract because you haven't performed.
Of course, we could also argue that on the merits, but we think it's a question of the plea to the jurisdiction. I think they need to bring a scintilla of evidence that they've done the things in the contract that entitle us to any kind of right or service or good. And they have never done that in this case. This contract, as it stands, as it was signed, obligates us to nothing. It gives them all the rights to do whatever they want in terms of developing this property or not. And until they perform, we don't have any rights against them. And so I don't, this, in that sense, it becomes
You have a right to retain the plant, right?
If indeed the record showed that they had handed over the plant to us and that, we have the realty, I understand that that is probably the situation. I'm talking about the record that is before this court. If they had shown at the plea to the jurisdiction stage that, look, here's the property we built for you, here are the, deeds handing it over to you, I suspect we do have the right to keep that property. But again, that is perfectly appropriate for them to decide, okay, we spent $1 million or $500,000.
But you said you didn't have any enforceable rights, and you do, now you're saying you do have a right to keep the plant under this contract.
Well, I mean, if they've handed it over to us already, and again, I don't know what exactly is going on. I don't know that that's an enforceable right. That's something they did voluntarily. We could not compel them to hand over the plant. I know.
But I think what you're saying is they can't get it back from you. You have the right to keep it.
Your Honor, I haven't thought about the question of getting it back. What I'll say is I don't think they have anything they could do with it. It's excess capacity they built off-site so that their 1,500 EDUs could be serviced. And then
That seems like a different question of whether what its value is. But you said, I'm just trying to figure out if there's an enforceable right, because you said there's not one, and it seems like there is.
Your Honor, all I can say is that we can't enforce them to make that plant. We could never have forced them to do that. Once they hand it over, I suppose it's, fait accompli. It's kind of done. I'm not sure they could get it back. They don't want it back, as far as I can tell from the pleadings. What they want.
Well, it certainly has value to them because there are people paying you to use it.
I don't think it does any value to them, Your Honor. I'm sorry
Well,
to quibble, but I don't know what they could do with it.
You wouldn't pay to get it back?
I'm sorry, Your Honor?
You wouldn't pay them to buy it?
I have no idea. But I don't think they would ever pay any money to get it because there's nothing they could do with it. It's not connected to their system. There is no system. They never built it. They never connected to the rest of the sewer system.
If we get past the unilateral, bilateral issue, why isn't building sewer infrastructure that you are now going to own providing a good or service to the government?
As a matter of theory, it is. So if you look at Kirby Lake, that is exactly what happened there. You offered to buy sewer infrastructure and hand over sewer infrastructure. So we think in that case, there's waiver of sovereign immunity, as this court has said. But the question is, do we have a right to it? That's what Lubbock County says. Does the government actually have a right to the good or service? And here we had no right to the good or service because they never completed the unilateral option agreement that they entered into.
If it turns out there was the same kind of agreement in Kirby Lake, going through all the different opinions that were issued in that case, that the agreement there was pretty much like the one here, would you concede that you lose?
If it was exactly the same, yes, Your Honor, but I have reviewed that contract. It's attached to the petition, the brief on the merits in Kirby Lake, and it is fundamentally different. It is a direct exchange of money for a product within a term of 1 year. There's not that aspect of perpetuity and tying the government to the mast for 30 years that exists in this case.
Any other questions? Thank you, Mr. Melkonian. Mr. Jefferson, I believe you have 5 minutes.
Thank you, Your Honor. First, with respect to the question of was this built? In the first place, in the Court of Appeals, the opinion says it's undisputed that it was built after full briefing and full argument. SAWS has never said that it was not built. We built the infrastructure that we said we built, and in the record is included at page 190 an email exchange where an engineer says, "It seems clear that alternate 3 was chosen, funded by developer, and constructed." There's no question that this was built. They've not denied that it was built, and in a plea to the jurisdiction stage, this court is bound to accept the allegations the factual allegations that we make. So there's no question that it's in the ground, and that's the fundamental problem here. We delivered to them sewer infrastructure. They delivered to us nothing. Nothing. And they say they don't have to.
Was sewer infrastructure all that you were required to deliver?
No, there are many contractual obligations.
What about, in particular, the impact fee?
The
'Cause
two
that's
things
one
that they
that's
say they're
discussed.
Yes, Justice Bland. There are 2 things that they say that we didn't do. One is pay impact fees, and what they're talking about there are treatment fees, not collection fees. There are 2 different kinds of impact fees. One are treatment fees, and one is collection fees. The vested rights occur whenever we pay one or the other. That's what the contract says. Upon payment of the collection and/or treatment facilities components of the impact fees herein, we acquire vested rights. We own those EDUs. By constructing the infrastructure, we paid for the EDUs. That's what the contract says. So we have vested rights to EDUs that can only be used on that property. And we have credits that we can use in addition to those vested rights that we can use on other properties. That requires a calculation, but there are two things that we have. So the 2 things that they say we didn't do under this contract, one is they say we didn't pay impact fees. We did pay impact fees, and we paid collection impact fees, and that is clear from the language of the contract and from the record. By constructing the infrastructure, we paid collection impact fees. The second thing they say we didn't do is we didn't develop the subdivision. We don't develop subdivisions. We sold the land with the entitlement to EDUs, and there's nothing in the contract. I've looked through the contract in excruciating detail, and there's nothing in the contract that says you must connect to the system by X date, or you must build a subdivision by X date, or you must do anything by X date. What the contract says is you have a vested right to EDUs, to 1,500 EDUs.
So then what is the 10-year term all about?
Yeah, good question. I mean, the 10-year term doesn't say after 10 years they have to do nothing. What the 10-year term says is after 10 years we have to recognize your right for unused capacity. Remember, at the time this contract was written, that the infrastructure had not been constructed yet. So no one knew how much capacity there would be. But once we constructed the infrastructure, 1,500 EDUs were gone. So what the contract actually says is they have to recognize the 1,500 EDUs that we're now entitled to because we've built the infrastructure. And that they're not doing. They're saying, no, we don't have to recognize that even though you built the infrastructure. Instead, you got to spend $7.5 million more because we now don't have enough capacity to service the contract that we promised we would deliver to you. These are all merits kinds of questions. And I'm happy to. I mean, I think on the merits we win. So we can do this all day long, and I think that it's clear that we developed the contract in the first place is a contract for goods or services. In their core business, and the core business purpose of what SAWS is there for. They provide water and sewer service. We gave them the goods to do it, and we got nothing for it, even though they promised in an express contract that they would provide it.
You have anything you want to say about Mr. Melkonian's perspective on whether it's a bilateral contract that gave Saws any enforceable rights?
As I indicated before, I think there are aspects of the contract that are bilateral, and the contract requires us to do things. They're entitled to rely upon our promise that we're going to do things, and if they're damaged for it, they can enforce our failure to perform. We made a promise. The bilateral promises that are contained in the contract that makes it an enforceable contract.
Any other questions? Thank you, Mr. Jefferson. The case is submitted, and the court will take a brief recess.
All rise.